We, the people of the United States, in order to form a more perfect union, establish justice.
Congress shall make no law respecting an establishment of religion, or abridging the freedom of speech, or of the press.
In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state.
No state shall deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction.
The State of Iowa Plaintiff versus Glendale Moore Jr. Defendant. We, the jury, find the defendant, Glendale Moore Jr., guilty of murder in the first degree.
The judicial process, still working in this country 200 years after the Constitution of the United States was drafted. I'm Lyle Dean. When the scales of justice are balanced, the rights of a defendant in a court case are generally thought to be paramount. Conflicts have arisen over the years between those in the legal profession and those in the news media. And in recent years, that conflict is centered over whether radio, television, and newspapers should be allowed to record sound and take pictures in a courtroom while a trial is in progress. During the early 1900s, there was no policy on the use of audio or visual recording equipment in courtrooms. The trial of Bruno Hauptmann in 1935 was the turning point. It was a sensational and celebrated case. Hauptmann was charged with kidnapping and murder of the child of aviator Charles Lindbergh. The media created a circus-like atmosphere as reporters and photographers competed to interview the defendant and other trial participants. Much of the disturbance was caused by newspaper photographers and reporters, but the court placed most of the blame on radio reporters and technicians because of their equipment and the newness of the medium. The public's attention was now on the electronic media and whether it had a proper place in the courtroom.
You feel that if an appeal will be made, Dr. Sam will be found innocent?
I certainly hope so, if there's any justice in these United States.
In 1954, Dr. Sam Shepard was convicted of murdering his wife in their suburban Cleveland home on the 4th of July. The Supreme Court later said media coverage of Shepard's trial caused bedlam, and he was granted a new trial that ended in a controversial acquittal. But the largest blow to coverage of trials with cameras and microphones came after the Billy Saul Estes trial in 1962. Estes, a Texas financier, was charged with swindling and theft involving the federal government. The Supreme Court ruled that broadcast equipment, by its mere presence, interfered with Estes' right to a fair trial. The Estes decision set the pace for trial coverage for the next 10 years or so. Except for Colorado, cameras and microphones were banned from state courtrooms. But as equipment became less obtrusive and easier to use, a number of states allowed cameras and microphones to return. There were a variety of terms and conditions. The state of Florida adopted perhaps the most liberal rules. And in 1981, the Supreme Court ruled 2 Miami police officers convicted of burglary had indeed received a fair trial, even though cameras and microphones were present. Now the trend is toward more intensive coverage of trials by television and radio. More than 30 states allow cameras and microphones in their trial courts. As of now, Illinois has rules allowing cameras and microphones in the Supreme Court and appellate courts only. States that do allow cameras in trial courts, for the most part, have worked out guidelines with the news media designed to protect the rights of both the defendant and the public. News people control their own actions to make sure coverage is within the prescribed guidelines and that decorum in the courtroom is maintained. Today's equipment is such that good pictures and sound can be obtained without bright lights and flashbulbs or large obtrusive microphones. The video equipment runs silently, and camera placement, usually in the back of the courtroom, is such that there is no extraneous movement during the proceedings. Trial participants and observers generally don't give the cameras a second thought. 3 states bordering Illinois, Kentucky, Wisconsin, and Iowa, have allowed cameras and microphones in their trial courtrooms since the late 70s and early 80s. Iowa took the step in 1980 when its Supreme Court approved a 2-year experiment, even though the legal community was skeptical, to say the least. One poll taken the year before showed district judges were against the idea of 4 to 1. Supreme Court Justice Lou Lapparato used to be chief judge in the district that includes Des Moines.
I just didn't think it was appropriate or proper for cameras to be in the courtroom, and it might affect the outcome of the case. I had all those worries and problems, and didn't know how sophisticated the machinery was. I'd never had any familiarity with the equipment, so I didn't know what to expect. I had fear about it, and concern, anxiety.
Our association and our members really didn't know what effect it would have, and there were all kinds of fears that the presence of a camera in the courtroom or cameras in the courtroom would cause disruption of the trial proceedings, make it into a circus-type atmosphere. People were afraid that jurors would be hesitant to serve. People were afraid that witnesses would be hesitant to testify. Nobody knew, because cameras in the courtroom were new all over the country at the time. But I think all those fears are really unfounded.
The Iowa Trial Lawyers Association is still on record opposing cameras and microphones in the courtroom, even though Wiggins admits the system is working well. He says the association has simply had other matters to concern itself with during the intervening years and has not considered a new vote on its position.
Went into the district bench in 75.
Supreme Court Justice Jerry Larson was an early proponent of expanded courtroom coverage in Iowa.
Much of the resistance has dissipated. A lot of the feeling that witnesses would become so nervous that they would not be able to be effective. Fear that people might be so intimidated by the prospect of being on camera that they might not even come forward with their complaints and so forth. Ideas of lawyers grandstanding and so forth just simply haven't been borne out by our experience.
The Iowa experience has been successful largely because of a strict set of guidelines for using cameras and microphones in the trial courts. The guidelines, drawn up jointly by members of the media, the legal profession, and the judiciary, makes the judge the final arbiter in all cases involving expanded coverage. But administration of the guidelines and monitoring of news media conduct are up to the journalists themselves. A media coordinator serves each judicial district, and news organizations wishing to cover a trial with cameras and or microphones must make application through the media coordinator at least 14 days before the trial date. The Iowa guidelines address specific concerns regarding the protection of trial participants. For example, coverage of juvenile, adoption, divorce, child custody, or trade secret cases is not allowed unless everyone involved agrees.
A witness and or a victim in a sexual abuse case cannot be viewed as protected unless consented to. You cannot film the selection of the jury process, show any of the jurors. That's been protected.
Judge Strickler hears cases in Des Moines. He says he's probably presided over more trials involving cameras and microphones to date than any other Iowa judge.
And with the heavy caseload of the trial division, and I'm sure it's probably true in Illinois, it's certainly true here, we don't relish additional hearings. That's one of the misgivings I had, one of the apprehensions and concerns I had. But I haven't encountered that additional judicial functionality. I have yet to have one witness object in writing to being filmed.
In the fall of '86, 19-year-old Mark Smith of Bettendorf, Iowa, was charged with the stabbing death of his former girlfriend, 15-year-old Jennifer Crompton. The crime and the trial generated extensive Quad Cities area public interest and media coverage. All 3 commercial television stations, 3 newspapers, and 2 radio stations applied for and were granted access to the Scott County courtroom for the trial. The electronic media in the Quad Cities pool equipment to cover a major trial. The concern is to keep the amount of equipment to a minimum and in a compact form to cause the least amount of distraction possible.